Viewers, in this video, a 31st video, recording phone conversation, breach of privacy. This is the topic I am going to discuss. For data protection in the phone conversation recording by a party without the knowledge of the other party, there is no specific statutory regime in India. So as on date, there is no statutory regime to prosecute the person who will record the phone conversation without the knowledge of the other party involved in the conversation. Sometimes what happens is the phone conversation between two parties is intercepted by a third party which is not a party in this conversation. Sometimes it so happens that a third party will intercept the conversation, which is not at all a party to the conversation, and then recorded by this third party for the purpose of blackmailing or harassing or extortion of money, or to produce the re-recording of such conversation in the court of law as an electronic document of evidence. With that malign intention, the third party will intercept in the phone conversation, mobile conversation between two parties. The recording party is not a party to the conversation. So with a malign intention, the third party will record it, the phone conversation or mobile conversation. Sometimes it so happens that the government agency itself will intercept in such conversation between two parties and record the conversation for the purpose of investigation of certain crimes. Yes, it is followed. Such procedure is followed by the government for probing a case, investigation of certain cases. In the absence of a specific law governing the issue, the law most frequently applied to such cases is a dinosaur of law, as there is no specific law sections meant for prosecuting the third party intercepting and recording the conversation between two parties. The law applied is dinosaur of law. Under Section 25 of the Indian Telegraph Act 1885, intercepting any message by tampering a telegraph is an offence. Criminality is attachable only to a third party who breaks into the conversation by tampering telegraph. By tampering the telegraph, breaking. Section 43A of the Information Technology Act 2000 provides compensation by a body corporate to any person whose sensitive information, personal information, or data, personal data, such body corporate possesses or handles in a computer resource that it owns, controls, or operates. If on account of the negligence of such body corporate, wrongful loss or gain is caused to any person, he should be compensated, will be compensated. The Telegraph Act as well as IT Act, Information Technology Act, do not appear to criminalize the act of recording of telephone conversation by a party to the conversation. Yes. Action in tort or civil action can be a person aggrieved by such secretive recording of conversation can claim in tort for violation of his privacy. Tort law in India is uncodified, and therefore a court would look to common law for guidance in such cases for legal action. It's not codified. Therefore, they take guidance from common law. According to Indian Evidence Act 1872, read with the Information Technology Act 2000, The output of an electronic record, a phone conversation, say mobile conversation, which is saved in the form of an audio file and then the output produced on a CD or a DVD is deemed to be documentary evidence in the court of law. Under Section 65A of the Indian Evidence Act, electronic records are useful for evidence, and Section 65B of the Evidence Act lays down the requirements for admissibility of the electronic record in the court of law. This is the position of Evidence Act. Indian courts are of the view that there is no law in force that excludes relevant evidence, and the ground that it was obtained under the illegal search or illegally obtained, they cannot just neglect such evidence. They cannot say no to such evidence. They cannot say. The scope of the Section 14 of the Family Court Act, which permits reception and admission of evidence that may otherwise not be relevant or admissible under the Indian Evidence Act 1872, because the importance is given for the evidence, electronic evidence produced in the court of law in case of family cases, violence cases, violence, family violence, or you can say domestic violence, so marital disputes. It is accepted. Thank you, viewers. If you like my video, kindly share, subscribe, and comment. Thank you very much.